It is sometimes enacted that, before the minister comes to a decision, he shall hold a public inquiry, at which interested parties are entitled to adduce evidence and be heard. But that provision is no real safeguard, because the person who has the power of deciding is in no way bound by the report or the recommendations of the person who holds the inquiry, and may entirely ignore the evidence which the inquiry brought to light. He can, and in practice sometimes does, give a decision wholly inconsistent with the report, the recommendations, and the evidence, which are not published or disclosed to interested individuals. In any case, as the official who decides has not seen or heard the witnesses, he is, as a rule, quite incapable of estimating the value of their evidence. So far, therefore, as restraining the arbitrary power of the deciding official is concerned, the requirement of a public inquiry is in practice nugatory, and it cannot be of much value in enabling him to form a just conclusion. It seems absurd that one official should hold a public inquiry into the merits of a proposal, and that another official should be entitled, disregarding the report of the first, to give a decision on the merits. It is indeed sometimes suggested that these arbitrary powers are given by Parliament, who would not confer them in cases where it is considered that they are likely to be abused, but that is only theoretically true. In existing conditions, the Cabinet, as representing the government of the day, is, generally speaking, the real legislative power, Parliament merely confirming its proposals, and there can be little doubt that it is the officials in the departments concerned who initiate the legislation by which the arbitrary powers are conferred upon them. When Parliament passes such legislation, one may wonder how many members outside the ministry know what they are really doing. How much less do the people know what is being done in this respect by their representatives? It is inconceivable that such legislation would be passed, at all events without protest, if the legislators knew that they were sapping the foundations of the Constitution. All great constitutional lawyers have recognized that it is the rule or supremacy of the law, administered by independent judges, that is the basis of all our constitutional liberties, and it is this characteristic of the British Constitution which, above all, makes that Constitution admired throughout the civilized world. Arbitrary power is certain in the long run to become despotism, and there is danger, if the so-called method of administrative law, which is essentially lawlessness, is greatly extended, of the loss of those hardly won liberties which it has taken centuries to establish. One of the marks of despotism, as all history shows, is that it is unteachable. Its intrinsic nature, it would seem, is such that it must always, sooner or later, express itself in ways which are not only indefensible, but also quite manifestly indefensible. The fact is not, perhaps, to be regretted. If it were otherwise, despotism might have more dupes and a longer run. As it is, it exhibits itself, sooner or later, in a fashion which has the effect of exciting public observation, so that despotism is checked for a time, and has to start again. Attention has already been directed to a statute of the year 1925, the Rating and Valuation Act 1925, which contained the egregious provision that the minister might, if he thought fit, actually modify the provisions of the Act itself. That provision was piloted through both Houses of Parliament, but it did not escape remark. On the contrary, since it became law, it has on many occasions been the subject of criticism, not only in public speeches and writings, but also in the law courts. It might have been thought that the amateurs of the new despotism, unless they regarded public opinion with complete indifference, and unless they were also satisfied that they could count upon perfect complaisance or utter inattention in both Houses of Parliament, would avoid, at any rate for a time, the repetition of that particular revelation of themselves. But what followed? In the early part of 1929, a new local government bill was introduced, which contained a clause, originally clause 111, in the following terms. If any difficulty arises in connection with the application of this Act to any exceptional area, or in bringing into operation any of the provisions of this Act, the Minister may by order remove the difficulty, or make any appointment, or do any other thing which appears to him necessary for bringing the said provisions into operation, and any such order may modify the provisions of this Act so far as may appear to the Minister necessary or expedient for carrying the order into effect. Here, then, was another proposal to enact that the Minister, if he thought it necessary or even expedient, might by order modify the provisions of the enactment. The House of Commons did not like it. A good deal of water had flowed under the bridges, and a good many remarks had been made, in public and in private, some of them parliamentary and some of them less parliamentary, between 1925 and 1929. A storm, or at least a sort of storm, arose, and the Minister found it expedient, or even necessary, to promise amendment. But the amendment, when it came, was something quite wonderful. After a good deal of criticism, the amended clause, polished and pruned, was added to the bill, and emerged from the House of Commons in the following form, the clause now being numbered 120. If any difficulty arises in connection with the application of this Act to any exceptional area, or in bringing into operation any of the provisions of this Act, the Minister may make such order for removing the difficulty as he may judge necessary for that purpose, and any such order may modify the provisions of this Act, and so on as before. That is to say, the words, by order remove the difficulty, or make any appointment, or do any other thing which appears to him necessary for bringing the said provisions into operation, were taken out, and in their place the following words were inserted: "Make such order for removing the difficulty as he may judge necessary for that purpose," while the power to modify the provisions of the Act remained. Such was the official redemption of the promise given to the House of Commons to meet by amendment the objection which had been taken. Did ever a mountain in labour bring forth a more ridiculous mouse? The difference between the two clauses is, as the Law Journal truly said, February 23, 1929, a case of Tweedledum and Tweedledee. In fact, the practical effect is the same, and the Minister has found it impossible to carry out his undertaking and yet leave the clause in being. Nor is it to be supposed that either the Minister himself or any of the skilled advisers upon whom he depended was not perfectly well aware of the exiguous nature of the change. The House of Commons, it was believed, for some reason or other, would ultimately acquiesce, even though for a time it protested. What is significant in this transaction, it may be suggested, is the frame of mind of those who drafted and approved the original proposal and had the courage to put forward the amendment as removing the objection to it. The sequel is not without interest. When the measure reached the House of Lords, the clause had come to be Clause 123. In the discussion on the previous clause in committee, March 8, 1929, something had been said upon the provisions for laying before Parliament certain orders and regulations made under the Act. "We may be told," said Lord Strachey, "that we can have confidence in the present Minister of Health. I quite agree, but the present Minister of Health will not always be there, and we may have a Minister who will adopt a very hostile attitude towards county councils and local bodies and want to centralise everything in Whitehall. There is always that danger, and we must look ahead." When Clause 123 was reached, no amendment was proposed to the first part of the clause, which provided, in the terms already set out, for the making of orders that might modify the provisions of this Act. The attack, such as it was directed against the second part of the clause, which provided merely that every order made under this section shall be laid before Parliament as soon as may be after it is made. Lord Asquith moved an amendment for the purpose of adding the words, "and shall not be of any effect unless and until a resolution affirming the order is passed by each House of Parliament." The amendment, he said, would give a control to Parliament which has rather been before the country, and which the country desires, against orders being made by a minister without anybody else having any control. The amendment was afterwards withdrawn upon an assurance given by the Lord Chancellor. "I am quite willing," Lord Helsham said, "if your lordships think it right, that any exercise of the power of Clause 123 should be brought to the especial attention of Parliament by providing that, instead of its merely being laid on the table, and subject to disallowance by a resolution under Clause 122, in the case of an order made under Clause 123, there should be the necessity for its confirmation by an affirmative resolution within a named number of days after Parliament meets, after the order has been made." The last phase was reached on the report stage in the House of Lords, March 14, 1929. Again, the first part of the clause, giving power to make orders modifying the provisions of the Act, was allowed to remain in the form in which it had come from the House of Commons, but the second part of the clause, by the combined result of more than one amendment, was altered so as to read in the following way: "Every order made under this section shall come into operation upon the date specified therein in that behalf, but shall be laid before Parliament as soon as may be after it is made, and shall cease to have effect upon the expiration of a period of 3 months from the date upon which it came into operation, unless at some time before the expiration of that period it has been approved by a resolution passed by each House of Parliament. Provided that, in reckoning any such period of 3 months as aforesaid, no account shall be taken of any time during which Parliament is dissolved or prorogued, or during which both Houses are adjourned for more than 4 days." It is in that form that the clause now appears as Section 130 of the Local Government Act 1929, from all of which it will be seen that 1. That the power to modify by departmental order the provisions of the Act remains. 2. That every such order is to come into operation upon the date specified in the order in that behalf. 3. That the period of 3 months runs from the date so specified, and 4. That the proviso with regard to the reckoning of that period, although to the careless reader it might seem to involve an extension of the period of parliamentary control, in effect extends the period during which the order may be in operation without parliamentary approval. It may be observed that the Times, in a leading article in its issue, dated the 16th February 1929, said with reference to this clause, enabling the Minister by order to modify the provisions of the statute, "The true precedents, it has been pointed out, must be sought further back than 1888. They are the pretensions to the dispensing powers under the Stuarts and the statute, obsequiently passed by both Houses, which declare that anything enacted by King Henry VIII, or by order in council, should have the force of law." End of chapter 4.